I am often asked, what are the best steps to take for my Social Security disability claim? Now mind you, Social Security disability does not necessarily mean that you're old. Social Security retirement was put in place for people who reach a certain age. Social Security supplemental income was put in place to be a safety net based upon assets and lack of earnings. But Social Security disability requires that someone be disabled, not just from their regular job, but from any job that exists in significant numbers in the national economy, and that their disability is likely to last 12 months or more. So if I had 2 broken arms, but they were likely to heal in several months, I would not be an appropriate Social Security applicant, certainly not for disability payments. So, for Social Security disability, what you want to do is apply as soon as your treating doctors tell you you have a condition, an injury, or a disability that is going to last 12 months or more. The paperwork seems daunting. Just remember this, keep your answers very short and simple. It's not a time to write your major essays, and to get a competent, experienced lawyer who regularly tries Social Security cases. Social Security law is similar throughout the United States, so a lawyer who tries Social Security cases in Virginia would probably be just as good trying a case in the Washington, D.C. area. But you want someone with experience. You want someone who can prepare you before the day of your hearing. And you want to keep your treatment consistent. Just because you file a claim doesn't mean you should stop seeing your doctor if your doctor still needs to see you. Social Security judges look for several things. They don't look for conclusions by somebody saying you're disabled, even if it's your own doctor. They look for objective evidence of disability. So they're going to actually look at the treatment notes and the physical therapy notes and the other medical records like your x-rays, your MRIs, your CT scans, and your EMGs. If all of these things support objectively that you are disabled, then that will help your case. They tend not to listen to subjective complaints. Subjective complaint is, oh, this hurts, or I don't feel well, or I'm tired, as opposed to an objective finding, which is there's a broken bone, there's a herniated disc, there's discoloration, swelling, skin is hot to the touch, cold to the touch. Things that can't be faked are generally considered objective findings. If you have 2 or more regular treating physicians who have been consistent in their care, have kept good records, and you have several lay witnesses, that is non-expert witnesses like family, friends, and neighbors, that kind of evidence goes a long way to supporting a successful, a fully favorable Social Security case. When there's an absence of treatment, spotty treatment, inconsistent compliance with medical instructions, and no witnesses to support your stories of what you've been going through, then that evidence would be very weak, and it would be unlikely you could win that case. That is why speaking with an experienced Social Security lawyer early in the claim can help move your case forward and can help you towards a fully favorable opinion. If you are contemplating a Social Security disability claim, speak to counsel. There is no charge because they are on a contingency fee contract, meaning it is contingent upon their being successful.